Perfect. Hello, everyone, and welcome to our webinar, Resolving Commercial Conflicts with ADR in 1 hour. I'm Ana Ayub, Head of Marketing at the Spain U.S. Chamber of Commerce, and I'm thrilled to have you here with us today. We're here to explore how alternative dispute resolutions, ADR, can offer powerful and efficient ways to resolve commercial conflicts. ADR, including arbitration and mediation, provides flexible solutions that can save time and money compared to traditional litigation. We hope this session offers valuable tools and knowledge that you can apply directly to your business. Now, let me introduce our esteemed speakers. Thank you for being with us today, who will guide us through these topics today. On one hand, we have Javier Samaniego, who leads Osborne Clark's Miami office. Javier is an expert in international dispute resolution, IT, privacy, cybersecurity, and data law. He brings vast experience as an arbitrator and conciliator, and is recognized internationally for his work in commercial conflicts. On the other hand, we're also joined by Daniel Villeville, a partner at Assolin and Berlow in Miami. Daniel is a dual qualified attorney in Venezuela and the US, with a specialization in international arbitration and litigation as well. Welcome, and thank you for being here with us. Before we started, a quick reminder, okay? After the presentations, we'll open the floor to questions. So feel free to type your questions into the chat as we go along, and our speakers will be happy to address them during the Q&A. So without further ado, let's dive into today's topic. Javier, Daniel, the floor is yours.
Thank you very much, Ana, and thank you very much to, of course, the Spain U.S. Chamber of Commerce. Thank you very much to all of our attendees. We understand that today is a difficult day in Miami because of the storm, so we are grateful that you are joining us today. As Ana highlight, I'm together with my esteemed best friend and colleague, Daniel Villeville, who will complement this presentation from the US angle. But the background of this presentation were our previous discussions with the directors of the Spain US Chamber, where they realized that most of the companies landing in the US obviously see litigation as a big risk for their business. And apparently, we learned that there is a lack of knowledge and understanding of other alternative methods to litigation. So today, for those of you, of course, that are working in the area, this is going to be probably very basic, but we really try in a very humble way to give a little bit of light on the different alphabet soup, because sometimes you hear about the ICC, the CIA, the ICA, the ICDR, and we will try to put a little bit of light. But of course, both Daniel and myself will be very happy to follow up with questions, not only today, but after this session. So Daniel, if you agree, I'm going to start the presentation with something that, well, we can call the 3 main mistakes when foreign companies arrive to the US. And as sometimes the Americans, when they go to Europe, they think that Europe is just one country. Legally speaking, the US is not really one country. Is that correct, Daniel?
Javier, well, thank you. And first and foremost, I appreciate everyone that is attending this webinar, and hopefully we can provide you some useful tips for your day-to-day business and the resolution of whatever disputes you may have. Definitely, yes, one of the issues that foreign companies, when they come to the United States, is understanding that the United States is 50 states, and that each state has its own judicial system and its own set of laws. Obviously, there have been great efforts to try to unify commercial law in the United States. Thus, you see a lot of similarities, especially in contract drafting. At the same time, in some of the dispute areas like arbitration, because you are dealing with intra-state commerce, is subject to federal law, which is the Federal Arbitration Act. So you see a lot of similarities in that regard. However, there are obviously local particularities and also cultural and geographic that obviously makes that any company that is coming to the United States be aware of where it's going to do business, where are the parties, the customers are located, so that it's aware of potential differences between each state.
Thank you, Daniel. And actually, we will see that this is a very important choice, which is the choice of law that is going to cover of our contract. Because obviously, you know, when we are doing business in the US, we have seen in our experience that there are companies that just put New York laws or California laws, even if they don't have strong links to those geographies. But we will see that obviously that has a lot of consequence, in the same way that if you are doing business in Europe, you're subject to agreements to French law instead, or a UK law or a Spanish law. Also, we have to take into account the cost of lawyers in the US, because that's something that obviously is very different to other regions in the world. And also the different legal jurisdictions has a different cost. And please, Daniel, feel free to interrupt anytime. The second mistake is that, of course, when we are in the US, we are using English. I don't know if English or Euro English or whatever English, but clearly the source of conflict is always misunderstanding. And here you can see, you know, two people. One people is talking about art, I love Monet, and the other person is talking about money, moi aussi, which in French is yes, I also love money. So you see, this is a silly example of what happened in real life. In real life, typically we have two parties into an agreement that they have signed exactly the same agreement, but they have a complete different understanding of what is written down in the agreement. And sometimes that is because of the legal background, the legal understanding. We believe that we are saying certain things, and maybe the other party, because has a very different legal background, is understanding sometimes even opposite things. That's why our first advice is really in the US, which is a very, very litigious society, is always very important to be together with US lawyers that are going to help us that guide us, because sometimes the template or the model agreements that we use in our jurisdiction in Europe do not really match in the understanding with the US mentality. And that goes to my third slide. And Daniel, I would like if you can, which is the, again, we are being very, very basic, but we can say that there are two legal systems in the Western law, which is common law and civil law. And here we have some differentiators, but as a continental but also US lawyer, can you very briefly tell us, you know, what our the people listening has to take into account?
Yes, thank you, Javier. I think that this point is extremely important. There are, legally speaking, huge difference between civil law and common law. And we also have to consider there are significant differences between English law and US law. And for instance, like in the principle of good faith, which is a core principle of contractual law in civil law countries, in England has very strong, very complicated particularities that that normally limit that principle substantially. However, when you come to the United States, it's different. The United States separated from England with respect to how the good faith principle applies, and they went closer to Europe, to continental Europe in that regard when they approved the Uniform Commercial Code at the mid of the 20th century. So those are nuances that you see between laws that make very important that when businessmen are coming to the United States to really go hand to hand with attorneys to understand the difference, and even with attorneys coming from either Europe or Latin America, it makes extremely important that they clarify concepts with US counterparts, because there might be substantial difference in between the systems. For instance, the very basic notion of attorney's fees in a contract and in a relationship. In most systems in civil law countries, when there is a dispute arising of a contract or arising in general, it can be a tort or a hecho ilícito in jurisdiction. Normally, the party that prevails in a lawsuit is going to be able to recover the attorney's fees that is connected to the prosecution of that action. The United States is very different. In the United States, the attorney's fees do not arise naturally from the prosecution of the action. They are, obviously, if there is a contractual provision in a contract that includes an attorney's fee provision, then there will be an entitlement to attorney's fees. And there might be in other statutory legal situations in employment, in securities, in other, where there is a specific legal provision granting the right to recover attorney's fees to a party. But in general, there is no such principle. So many times we see that parties come from civil law countries and they say, well, we are going to get attorney fees. And we have to explain to them that's not going to be the case. And yes.
I'm sorry for interrupting, Daniel, because you are raising an important point. As we can see in this chapter, most of the Europeans are always very surprised because the agreements in the US are extremely long. And I remember when I arrived to the US and I have to list my first office, and really the agreement was completely crazy. It was more than 100 pages. The reason being, as you were saying, because contrary to what happened in Europe, where we have the civil code, and obviously you don't need to draft a lot of things because a lot of remedies in case of breach are in the civil code. Here in the US, and that's exactly your example, it's very important to write down and to anticipate a lot of things, because otherwise, if they are not written in the contract, you will not be entitled to that, for example, remedy or whatever. Is that right, Daniel?
Well, yes, in part, definitely, that's one reason, but also have to be careful, because it's not that there is no provisions in the law that cover all the same areas that you will normally cover in a civil code. Is that a lot of the development is by way of jurisprudence, it's case law. So even if there are attempts to unify and to create a compendium of those provisions, this obviously promotes parties being very careful about how they draft contracts. However, I think it's also a cultural thing in the United States that parties like to regulate almost every situation they can face in a contractual relationship. And even if you draft a very simple contract, to extend the law is going to provide you to complement the contract, and you are going to be able to establish what are the parties' obligations. In the United States, there is a tendency to create a lot of predictability. And the predictability is made in a contractual framework by having these long contracts where almost every scenario that the parties may face is already covered by them.
Thank you. So we are going to continue. That was the first part of the presentation. So to understand US as, not just a single country, all this jurisdiction, the two different legal systems. And now, in order that we understand because either we like it or not, this is like our personal life, disputes are there and in a way are inevitable, and we can face disputes. And as we were saying earlier, disputes, most of the cases, they are due to misunderstandings. So one party, even again, if the two parties have the same agreement, there is this different reading of the agreement. So when we have a conflict, and that conflict, think, in a conflict with an employee, a conflict with a vendor, a conflict with a business partner in a joint venture, obviously, if we go to the courts, or even if we go to arbitration, to an arbitral tribunal, typically we are going to ask the judge or the arbitral tribunal to examine the dispute, that we have with that partner, but the court can only decide about the effects of the dispute. But as you can see in this famous image, which is the iceberg, every time that there is a conflict, there is not only the facts, and the applicable law, like a mathematical formula, but there is a lot of under going issues that has created the conflict, that are the cause of the dispute. And maybe it's a misunderstanding between two partners, or a lack of trust because one day one of my American partner say something that creates some kind of lack of trust, and the thing is that all the emotions, all the feelings, all the misunderstandings, obviously a judge or arbitral tribunal is not going to be able to decide about them. So sometimes we resolve the dispute, but we do not resolve the underlying conflict. And resolving the underlying conflict is very important, particularly when there is an ongoing relationship, particularly between two partners, European partners and American partners doing business for 10 years, 15 years. So today we want that all the companies attending know that there is another way of resolving disputes, as Anna was saying in the presentation, which, apart from going to courts, parties can resolve the disputes themselves with the help of a mediator, and that is what we are also going to discuss today. Let me go to this photograph. I know that you cannot now intervene until the end of our presentation, but probably a number of you know and see, because even if this is a single image, a number of you, if I ask what can you see in this photograph, I don't know, Daniel, if you knew this one before we were discussing the presentation.
Yes, I have seen it.
Yes, and I don't know if you see the young lady or the old woman.
Yeah,
in your case, or you see both.
Yeah, but it makes obviously complicated so that anybody can get a different perception.
Exactly. So here, this is an example, and we are showing this example because sometimes we have exactly the same agreement. So, and typically a lawyer, your lawyer will tell you, no, the facts, if you remember the film Philadelphia, the facts, the facts, the facts. But the facts, are they objective or are they subjective? The thing is that there is a perception of the facts. And here, a number of people will see a young lady, another group of people, because their different background, even their sex, a lot of things, they will see the old woman, and there will be a number of people that, after explaining, yeah, if you look here or here, they will see both the young lady or the old woman. But the reality is that when we go to court and we try to see to resolve our disputes, maybe the judge or the arbitrator or the arbitral tribunal can only see the young lady or can only see the old woman. So that's why, I mean, our advice is that to the extent that is possible, is try to resolve the conflicts ourselves, because otherwise we always risk that if a third party is going to resolve our disputes, it's going to resolve according to his or her bias and his understanding of the facts. And again, this is a silly example, but here, as you can see, there are three animals, and every animal, depending on where the animal is placed, is the moose see a square, the cat see a triangle, and the dogs see a rectangle. Are they wrong? Are they right? The reality is that sometimes, and again, when we go to court, depending on, a lot of bias, perception, or understanding of the facts, even if we are convinced that we have a rectangle, the judge is going to say, no, there is not a rectangle here, there is a triangle. Okay, so this is what we want to show you these slides. Take into account that this is a theory that from Friedrich Glatz from the 19th century, but this works very well for every conflict, from your family conflicts with your kids or with your couple, to your more complex conflicts with your partner in a big joint venture. Typically, conflicts sometimes start with a little disagreement, but things, if they start to escalate, they can really end regretfully in the let's say the domestic sphere, even with the killing of someone. But in the corporate war, they can end with a litigation of 20 years, and a common destruction of the two parties. So that's why it's very important to introduce elements in the contract in order to try to de-escalate the conflicts. And again, here we believe that disputes boards, mediations are a very good tool to try to reach a settlement, to reach agreement without the alternative of going to a judge or an arbitral tribunal, which in our view is always a very costly, and of course, I mean, sometimes both Daniel and I litigate and both of us go to arbitration. But our advice for today companies doing business in the US is try to avoid always litigation, arbitration, and try to resolve the disputes amicably. So what are the methods? And here is that Juan Carlos and Ana from the Spain Chamber of Commerce ask us to give some light on what is the alphabet soup, because when you talk to lawyers, they talk about a lot of acronyms. And so today we're going to try to give some light. So Daniel, maybe you can give a quick overview. Sorry, I need to go back in the presentation to the existing alternative. I mean, when we have disputes, typically we have these two groups, the delegate procedures when a third party is going to raise a decision, and the autonomous procedures, which is when the parties are going to reach an agreement. Can you make a quick, brief explanation to our audience on these methods?
Yes, or the way the slide describes the way that they are divided, obviously put it in a way that is a little bit, one side or the other, and you have to consider then that they are, the hybrid part is important. So you have the procedures that normally appear when there is an actual dispute and when the parties submit that dispute to a third party to decide. You have court litigation, the parties go to a court proceeding, they file a complaint, there is an answer, and the case is going to proceed. There's going to be evidence, and it's going to be resolved by a judge or by a jury in the case that the case is subject to a jury trial in the United States. And that's one way. Then you have arbitration, which is similar to litigation, but it's going to be resolved privately by a party appointed by common agreement by the parties or by an institution. Then you have the other procedures, which are little, let's say, skirmishes in certain type of projects, like expert determination, adjudication, and dispute boards, where you have in construction contracts, large projects, when there is a difference between the parties, they already selected in advance some expert, some technician, some technical assistant who is going to resolve that little or that specific problem so that they can, and the contract will keep going. And that is a very, very useful methodology for large projects. The normal contracts, obviously, that normally agree, but it's also very important to keep them in mind. And you have the autonomous proceedings, which they resolve out of an agreement, like mediation and collaborative practice. Those are less used, at least in the United States. There is obviously direct negotiation, and there is obviously proceedings that come out of cool-off periods, pre-litigation, and those are very, very useful. They are normally undertaken by the parties itself. Lawyers don't get involved that much. I think that is something that needs to be a little bit more careful, because there is a very old saying that the problem in business in general is that there are too few lawyers at the beginning and there are too many lawyers at the end. And so I encourage parties to, when they are negotiating, resolving a dispute, to already incorporate lawyers, because if those lawyers can somehow get together, in most cases, they actually resolve the dispute together with the parties in a way that is going to avoid all the complexities and costs of going to litigation or arbitration. Then you have the hybrids. Tell me.
Yes, actually, a questions that we typically receive is if when, and I know that every lawyer will reply depend to this question, but when in an agreement is advisable to submit the agreement, for example, to the courts of Florida, when is advisable to submit to arbitration, and we will see that there are different institutions, and if we need an institution or not, and when we can go to an hybrid. And this is something that we are going to continue. But my first question is that, can we always choose, or is there certain cases where we cannot go? And obviously here we are not talking about family disputes, we are not talking about consumer disputes, we are just talking about a business-to-business relationship. But is there any situations where we cannot choose, Daniel, and of course in general, because I know that this is a technical complex question, but
I believe that in B2B, you can always choose. There are really very few limitations. And obviously,
exactly.
like you say, even consumer disputes in the United States are in generally open to arbitration. And that is what parties do. And I will encourage parties to really be careful having those clauses in their the consumer contract.
No, and thank you, because that is what the main message is, that with certain exceptions, and this is important for our audience, even if you are negotiating with a tough American party, you can, it's very important, because sometimes we spend a lot of time, and obviously for good reasons, negotiating the prices, negotiating the commissions, negotiating the economics of the contract. but sometimes we do not spend enough time negotiating the dispute resolution mechanism of the contract. And as you say, in most cases, it's possible not submitting to the courts, but submitting the court, for example, to arbitration. And we will see, because, for example, in international, clearly is very advisable to go to arbitration, if particularly we are in jurisdictions where the court system is not very reliable, as in a number of Central American, with all respect, and Southern American jurisdictions where maybe we can have doubts about the independency of the courts, or even the speed in which the dispute is going to be resolved. I think it's important that we launch this first message, that when we negotiate agreement, we can take into account all these different mechanisms and include in the agreement the one or the hybrid that, sorry, Daniel, because I interrupt when you were going to jump into the hybrid, but I really want to stress that this is something that is subject to the parties' will to be able to use the different mechanisms, right?
I would like to distinguish with that. I think that's a very important point. And the issue of mediation as a hybrid system with the what they call here in the slide the delegated procedures. And we have to distinguish mediation within United States litigation and mediation in
That's very
arbitration.
important.
And a mediation in the United States has been extremely successful. Perhaps the most successful country in the world where you consider the use of mediation in the judicial system. In the United States, when you are in court proceedings, I will say in every state in the United States, mediation is going to be mandatory in all proceedings. And it is, especially in the B2B setting, and especially if you are, for instance, at the federal level, you are going to have to mediate between, at some point in time during your litigation. And I think that's one of the greatest inventions of in the history of law. And having mediation in the United States, it has proven to be extremely effective. I would say that in our practice, 3 out of 4 cases are resolved in mediation in courts. And it's an extremely important, and the ones that might not be resolved during the mediation, that mediation is going to serve as the predicate for a subsequent settlement between the parties after that mediation. But the bottom line is that mediation is extremely important, it's essential. It's obviously like it's a litigation tool. So as a litigator, you need to understand when to go to mediation, when the dispute is ripe to be resolved in mediation, and that's kind of an art more than a specific moment. But the bottom line is that for people that are coming from abroad, I always tell them to be extremely open to the idea that their disputes will be resolved in mediation. However, probably they're going to be resolved in mediation after the dispute has arisen. Pre-litigation mediation, I found to be, first of all, you don't see that many clauses when the parties agree to mediate before starting a dispute. That's obviously regretful, but that's the case. But in those cases, I think that the problem is, and it's a little bit combined with that chart that you just show about the different stages of when is the target zone to settle a case and to negotiate. And I think that at the beginning, sometimes the parties are more involved into the annihilation side of the dispute. They're in this red area or in this yellow area, unless in the green area. So at the beginning of dispute, sometimes people are not ready to really get into that green area, and that is a change, but I think it's a reality. Now, when you get into litigation, then you start having people are starting to really learn about the other party's case, about the other party's evidence, and there is a moment, and I believe that all the cards are on the table for the parties to really make a scientific analysis of what's the case worth, what are the risks, what are the potential rewards, what are the actual numbers involved. So mediation starts being very logical because it starts becoming very scientific in how you reach what is an acceptable settlement for one of the parties. In the United States, there is obviously a compounded aspect, which is cost. The United States, and it happens the same in England. The United States probably has, in my view, and maybe I'm biased, the best legal system in the world. However, it has one big effect, and it's cost. Litigating in the United States is extremely costly for many reasons. How lawyers charge, the discovery process, which can be very expensive. E-discovery. There are many issues why that makes litigated experts litigated in the United States very expensive. But the system is actually you see the where the money goes in the resolution. But however, it's difficult for a party to keep up with a litigation in the United States. That's why mediation is so important, because mediation comes and in a way save a party from keeping spending, saving face. There are many reasons why you want to mediate and what you want to settle a case. But at the end, mediation has a lot more importance in that setting. That's why we are at our firm extremely promoters of mediation. Several of my partners are mediators, and we encourage and we litigate the cases in a way that we try to get to mediation during a litigation to try to be that the mediation be effective. In arbitration, that is a big challenge. Obviously, it would be amazing that mediation would become an indispensable part of arbitration in general, be domestic, be international. It creates more risk, and I think one of those is that we want to make arbitration very efficient, and we want arbitrations to end very fast, and we want the case and to be subject to, especially in the commercial setting, we want the case to be subject to the arbitrators and have a hearing within a year. The case is filed at the most, and the sooner the better. Obviously, that creates some logistic problems to incorporate mediation within a procedural rush that everybody has to get to the final hearing in an arbitration. So that creates a little bit of difficulty. However, yes.
No, and sorry, Daniel, because in the interest of time, we need to move to in order to give light. But I think that your message today is very important, and that even if in your agreement there is no a clause submitting to mediation, in the US is really, as you say, not strange, at least that if you have started in court, that you have the opportunity to settle. And in arbitration, you are right that maybe it's a little bit more difficult. So that's why, again, I think a message that we are doing today is that when there is a magic moment, and it's when you are negotiating agreement. Obviously, if you introduce the possibility in a step clause, I mean, you try first mediation, and if it fails, going to courts or going to arbitration, maybe that can be a good idea. But sorry for interrupting, but the Spain US Chamber was very interested. We already covered the comparison between the two mechanisms. That there is a lot of, let's say, noise when we lawyers speak. And I would like to ask you, what is the difference? Because sometimes you hear lawyers that say, I do investment arbitration. Others says, no, I only do commercial arbitration. Can you very quickly tell our audience what is the difference between commercial and investment arbitration as a first differentiator into these two words, very briefly?
Yes, well, commercial is arbitration arises out of disputes connected to contracts between parties, and it can be even a government or it can be even a state-owned party, but it's in a contractual relationship, and the relationship is commercial in nature. So in those cases, you are in the field of commercial arbitration. You in that, as the slide says, you have the issues of, you can get provisional measures like in a court proceeding. You could, then you get an award and you can go to enforce it as a judgment. And there is a huge convention called the New York Convention that allows the enforcement of arbitral awards. And you submit, the most important part probably, and the largest benefit is that you submit your decision to experts and professionals that are really familiar with the dispute. So those are normally the arbitrators. Then in the investor stay arbitration, is the dispute arises normally out of a treaty. So it's a treaty between two countries that grant the right to the investors from one country to invoke arbitration when they are subject to measures in another country that are considered a violation of the treaty, like expropriation, fair and equitable treatment, this national treatment, and therefore you go to an arbitration, but the source of the arbitration is a treaty. Now there is a huge convention called the ICSIC, or the CIADI convention in Spanish, that provides for a procedure and the administration by an entity close to the World Bank that gives this institutional framework to process all these disputes. However, you may also have disputes at the Permanent Court of Arbitration or other at the ICC or other institutions. But that's the main differences.
No, thank you, Daniel. And here, our main message to our audience is that when you are considering, and particularly a number of companies in Florida that are investing in countries, for example, in Central or South America, when you are considering investing in a country, a way of protecting your investment is also taking into account what are the treaties, the bilateral treaties that that country has in place. Because sometimes you can, for example, if there is, if you are, imagine, Italian, and you are investing in Bolivia, but there is not a treaty between Bolivia and Italy, maybe you can choose, with all a lot of careful and in a meaningful way, a vehicle, for example, a Spanish vehicle, to invest in Bolivia because there is a treaty between Spain and Bolivia. So it's important that in the same way that we explore the country where we are going to invest and we do our market search, that legally we also explore what are the treaties in place in order to protect through these treaties, bilateral, sometimes are bilateral treaties, other times are like the former NAFTA, are regional treaties, sometimes is sectorial treaties like the energy chart. But the message for today, which this is we recognize a very basic initial presentation, is that you take into account that apart from the agreements between the two parties, when you invest in countries, you also have the protection of the treaties. Next difference, Daniel, that we next differentiate on is the so-called institutional versus the ad hoc. We say that in an agreement, we can decide to go to arbitration, for example, in a commercial agreement. And there are institutions that administer those arbitrations, right? And in the Spanish chamber, they told us we are a little bit confused on what are these institutions, what are their role. Obviously, this is not exhaustive list, but maybe we can give a quick overview of this institutional versus the ad hoc, because we can also say in the agreement, but we just want that our dispute is decided by an arbitrator without any institutions. What do you think is the main difference, and what you will advise? Is always an institution a good idea? Go to an institution? Is that very costly? Can you give very quickly some light, Daniel?
Yes, so obviously a difficult assessment at the end what is the best thing to do. Obviously, you have first to distinguish between investment arbitration and commercial, because investment ad hoc arbitration works very well because of the UNCITRAL rules and the management of those disputes within the permanent court of arbitration. So it's not such a big issue, and you have many arbitrations going that dog route that is also very good. Obviously, you have institutional. The one that you would like to go is the ICSIC route, if allowable under the treaty, because of the ICSIC, the ICSIC convention provides that arbitral awards rendered under ICSIC are going to have the force of domestic judgment of the country where you are enforcing. It's a huge advantage. But if not, anyway, the difference are less important. At the commercial level is when you see huge difference between going one route or the other. I would never recommend a party not to choose an institution for a commercial arbitration. And the reason is that because of the institution is really justified by the structure that provides having an institution with the arbitrator, or with the appointments of the arbitrators, with the review of the award, with the even communications. All that is really an advantage in going in ad hoc. You can have ad hoc, and it's great that we have ad hoc arbitration, because those are the default domestic arbitration rules. For instance, in Florida, let's say you have an arbitration clause that says the parties agree to submit exclusively to arbitration in Miami, Florida. That clause is valid. That clause is enforceable. And if you go to a court in Florida, the judge is going, if the parties do not agree, is going to appoint an arbitrator. And then the Florida Arbitration Code for domestic arbitrations or the Florida International Arbitration Code provide the procedure that ad hoc arbitration is going to follow. So you are fine. However, it's going to be messy. It's going to require a lot of cooperation by the lawyers and the arbitrators so that you actually carry on with the procedure. You don't have that problem when you are dealing with any of the institutional. And here you see all the different, this is especially the ones in Madrid, CIAM, CIMEM, CIMA, and then you have the International Chamber of Commerce, which is the most used institution. And then you have the International Center for Dispute Resolution also, which is extremely popular in the United States for international disputes and in Latin America. And they are, all of them, you have the London Court of Arbitration in London. You have every country.
We are going to review in next presentation. Actually, we are going to see that, but I agree with you. I agree with your conclusion that when we are negotiating the agreement, if we decide to go to arbitration, even if, of course, all these institutions are going to charge an administrative fee, they are very professional. They are very professional helping to choose the right arbitrator to our case. They have very well-designed procedural rules. And I think, of course, you can never generalize, but I echo Daniel's advice of trusting one of these institutions. And here we are, and again, sorry, these are the, well, it's just a selection of the most prestigious institutions. Obviously, I mean, both Daniel and I work with these institutions, and we have experience with all of them. We cannot say, I mean, submit to your agreements to the ICDR or to ICC, because really depends on the parties in agreement, in a lot of elements, on the geography. But what we want to stress is, because sometimes, and again, the chamber told us that a number of entrepreneurs believe that the only provider is the ICC, because obviously the ICC is probably the most well-known institution. But it's important to highlight that there are other institutions, and you cannot say, that there is one size that fits all. I mean, depending on the agreement, it's reasonable to choose an institution or to choose another institution. So here you have a selection of the institutions. Then and I'm conscious of time because we are 10 minutes left to the end of our presentation. We also want to clarify, so those are the arbitration and mediation institutions, but in the arbitration world, there are other associations, and it's important to highlight that these associations, they do not administer arbitrations or mediations. They are institutions, like for example, here in Miami, we have the Miami International Arbitration Society, or in the Spanish-speaking world, the CEIA, the Club Español Iberoamericano del Arbitraje, and their role, their association of professionals, they provide with soft role rules, and basically the role is to promote arbitration or mediation as an alternative to court litigation. But they are not administering, they are not institutions administering your case. And it's important that you understand what is these associations do. I think that we are at the end, but before finishing our presentation, and Daniel already put an example of a clause, but we are going to see this is real life because obviously, I mean, we need to be a little bit theoretical today, but this is a good example of clauses that we see in the agreements. So let me go to the first one, Daniel, and to ask you whether this is good, is bad, or is an ugly clause. And it reads, in case of arbitration, the London court rules shall apply. In case of litigation, any dispute should be brought before the courts of England. What is the problems that you see in this clause?
Well, that clause is ugly, definitely.
I agree. I agree. And can you tell our audience what is this clause that ugly? What is the problem if we have a dispute and we have in our agreement this clause?
Well, because any arbitration is similar to litigation in the sense that both are disputes, and therefore you will have to completely alternative mechanism to resolve the same dispute. So that clause would be incongruent.
There is a big incongruency. So and then there is a problem, and this is very typical in the agreement, and is that the London court does not exist. There is no an institution that is London court. The official name of the institution is LCIA, which is the London Court of International Arbitration. So if you are the claimant, and you want to start a proceeding against the other party, well, if the problem you have is you go to the London Court of International Arbitration, because I say, well, it's clear that this is where I submit my disputes. In London, there is another court of arbitration whose name is very similar because it's the London Commercial Court of Arbitration. So it's very important that we use the institution clause standards and try not to be creative, because if you go to the litigation, then the other party say, no, this agreement is subject to arbitration. So we will be probably 1 year just discussing jurisdiction, whether this goes to arbitration or whether this goes to the courts. Well, as we are running out of time, let me just go to the next one and to see what do you think of the next one. Any dispute arising out or in connection with this contract, including any question regarding its existing validity or termination, shall be referred to and finally resolved by arbitration under the LCIA rules. The LCIA, as we said, is the London Court of International Arbitration, which rules are deemed to be incorporated by reference into this clause. The language of the arbitration should be Spanish.
Yeah, well, that clause is good. That will be in general a normal clause. It might have a little bit of miss a little bit of detail that you can improve upon, but what you can be certain, what is important here is that the London Court of international arbitration rules will cover the vacuums in information in the clause, and that clause will be completely operational for the dispute.
Yeah, here the only thing, as you say, is that the clause means, for example, and because we have the good clause is the last one, where you set out the number of arbitrators, whether it's one arbitrator or it's a tribunal of three, but as you say, it's an operative clause. But the best, and that is the last clause, is really the model clause, where you will have how many arbitrators, because obviously for minor agreements, maybe you don't need a tribunal, because a tribunal of three arbitrators obviously is more costly than only having one arbitrator. So I think that we are done for today. These were just examples of clauses. And here you are our email addresses for any follow-up questions. But I think, Anna, if you are with us, that we have maybe some 5 minutes left for any questions from our attendees.
Yes, indeed, and thank you both so much for sharing everything, your expertise today. I found it very interesting, and we covered like a lot of ground on ADR. So we have like a couple of questions here. Let's see if we have like enough time to answer them. So Marta Rivero commented that this is more of a comment, but I wanted you guys to tell us if you agree. She commented that conflict resolution clause is a copy paste and parties don't pay too much attention until there is a conflict, and that parties don't pay attention, on this clause, on the conflict resolution clause, when they draft the agreement. So I wanted to ask you, like, do you agree on how can businesses be more proactive in considering like their conflict resolutions options during contract negotiations?
Yes. Well, I mean, obviously that comment is completely on point. And that's a big issue that arises, and companies have to be very careful about it. And when you are in a big firm, you see who are the real careful corporate lawyers, because the careful corporate lawyers that are putting together an agreement, they normally reach out to the arbitration people or the litigation people in their firm to ask them what would be the right arbitration clause if the case is arbitration, to incorporate in the agreement, because many people made that mistake of cut and paste clauses that are already in other agreements, and that then that can create in the future a big problem. Sometimes it doesn't, but many times you are arbitrated in a place you don't want, in a language you don't want, or using an institution that is not the most adequate for the dispute. So yes, I will recommend to that always you, with arbitration clause in any contract, that you at least consult a litigation arbitration lawyer to confirm that is the adequate clause.
Yeah, and let me add that by choosing, we have another presentation where we can demonstrate that depending on how you bad or how you good negotiate the dispute resolution clause, you can be spending between 3 and 5 times more money, and you can be in a situation between 6 months resolution of a dispute or years for resolution of a dispute. So it's of paramount importance. It's not really a silly thing, but yes, as our colleague was saying, regretfully, sometimes these clauses are considered like sometimes the boilerplate. It's like something that you take, but the consequences are huge.
Okay, perfect. Thank you so much. And also, Maria Rivero was asking, are the list of arbitrations in the institutions public?
Are they?
Are the list of arbitrators in the institutions public?
Well, here depends on the institutions, because there are like two models. For example, CIMA, which is the commercial is the Civil and Mercantile or Commercial Court of Arbitration of Madrid. They have a closed list of arbitrators. So when you submit to CIMA, you have the list of arbitrators, and you can choose between the arbitrators in the list. In the last year, the tendency to avoid, and to allow freedom to the parties in order to choose their arbitrators, there is no closed list, so the parties can choose their arbitrators. And typically, in case of disagreement, because obviously when the parties are in a big disputes, they are not going to agree in anything, So that's why it's important to submit to an institution, because the institution typically has a committee of designation of arbitrators, and the institution will choose the right arbitrator for your case in terms of specialization, in terms of language, because, for example, sometimes, particularly in our region, a lot of agreements or parties, are Spanish-speaking parties, so you will take care in order to choose a bilingual or a Spanish-speaking arbitrator, so it will be the institution. But I will say that we have the two models. For example, the ICDR has a roster of arbitrators. CPR, actually Daniel and I, we are members of a number of rosters of arbitrators, and it's like a selection criteria in order to be appointed arbitrator. So not everybody can be arbitrator, but typically, other institutions do not publish the list of arbitrators.
Okay, understood. Thank you so much for that. I'm gonna do one more because we are running out of time, but Blake Bierman told me, my question is, how would you compare the options for businesses in Spain versus in the United States to reduce the cost of ADR through insurance, third-party funding, etc.? Good question, right?
Yeah. Daniel, do you want to
Well, I can say, obviously, that might require a long answer, but it's a very good question. And obviously, there are methodologies to that. And I will say that in arbitration, the cost has a tendency to be more similar between countries, maybe with the exception maybe of the rates of the attorneys that you are selecting, as rates in England, for instance, are pretty high. And in the United States can also very high. In Spain are probably more affordable. However, you can select lawyers. The good thing with arbitration is that you can select lawyers from one jurisdiction to handle an arbitration in another jurisdiction. And that way allows you to save money. You can, I have many colleagues from Venezuela that have done arbitrations in Miami. And so that is good, because a little bit the restrictions that you have with the practice of law can be a little bit more play around in these circumstances that in litigation, obviously, you need local lawyers. However, that is one aspect. The other aspect is that, it's becoming more and more frequent to have contingency agreements where lawyers become partners with the clients in the cases, and they do hybrid ways to save fees for the parties. Third-party funding is becoming a huge thing in commercial dispute, especially in the investment state level, but also in commercial. So there are many ways that insurance, it depends. But in general, yes, there are very creative ways. I think that after COVID, you have seen a lot of increment in how lawyers are working with the clients to provide alternative methods so that they can afford litigation or, more important, arbitration. So yes, there are many ways that we are working towards that.
And the question, thank you very much for the question. The question is very good, because obviously, enter into, I'm now arbitrator in construction disputes, and this being a dispute of, in this case, it's not a Spanish construction company, but it's well, let's say a European construction company, and third-party funding, which for the audience that is not familiar, is these litigation funders that are willing to invest money in these cases is really a very good tool. The problem is that the threshold for investment are really very difficult. So if, Anna, you want to litigate against a vendor, a minor vendor, because your car has a problem, a litigation funder is not going to fund your litigation. This is really for huge disputes. So I think that third-party funding is really an incredible tool that we need to take into account. But the reality today is that due to the stringent investment criteria of the funders, they are not willing to fund any litigation. So, it's a good tool, but it's not that. I mean, I don't want to give the message that everybody, you can litigate in the US, no problem, because a litigation funder is going to support your litigation, pay your lawyer, pay your experts, because, these guys are doing investments, so they will only fund you if they believe in your case and if this case is going to give a big return. So it's really, of course, I mean, if one of our members, because in the chambers we have a number of Spanish construction companies, and of course, imagine if one of them, one of our associate members is doing a highway in Texas. Obviously, for those projects, if something goes wrong in those big projects, this construction company can discuss with a litigation funder, and the litigation funder, if they see, because they make an assessment and they say, okay, we believe in this case, they will be funding the case. So I think for those cases, for sure. But, let's take into account that it's only for those cases. Insurance, I really like the question, because a lot of people, in the same way that in our domestic life, we forget that, if something happened to all these books, because I have a flat, I can be, compensated. In the corporate world, there are plenty of insurance, D&O, directors and officers, PI, and a number of them cover the cost of lawyers and apart from the contingency. So thank you for the for raising this, because I think that for all these companies doing business in the US, I mean, having a good insurance, in the same way that Anna, when you and I arrived to the US, and we were advised on the insurance of the car, because in Florida, blah, 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 and the importance of, I think that for corporates doing business, insurance is also very important. So I think it's a good question. Thank you.
No, thank you to you. Thank you so much for your time. I think that was like the last question. Time is up. But a lot of people is asking about your email information and if you have offices in Florida. And I want to tell them that I'm going to send you the full presentation that you presented today to all the attendees that have joined today. So you will have that. And this webinar, along with others, will be available on our YouTube channel. We will send you all the information too in the email. And thank you once again, Daniel, Javier, for your time today. It was very interesting, and I think that a lot of attendees enjoyed too and find it very useful. So thank you so much, everyone. See you next time. And for those in Florida, be safe. Thank you.
Thank you very much.
Thank you. Thank you to the chambers and to the attendees. Goodbye. Thank you.
Likewise.
Bye-bye.
Bye.